so that I know everyone's listening to me. How's everyone of you doing? Hello, am I audible? Okay. Thanks for replying, Tarun. Okay. So, without wasting time, let's begin with the session. I am going to teach you a new trick today when it comes to contract drafting. Okay. So, I am not sure if I'm introduced. I am Mrunmayi Vatkare. I have 6+ years experience in international arbitration, construction contracts, and contract drafting as well. Since 2 years now, and I am teaching contract drafting, not just international contracts, but also Indian domestic contracts. So today, in today's class, all of you, I would want everyone to be actively participating in this session. The comment box is open. Please feel free to put your thoughts, your answers in the comments. If you have any questions, you can ask right now, or you can wait until I finish the entire session. Okay? Am I audible? Am I clear to everyone? Yes or no? Okay. All right. So today we are going to see one important thing regarding international contract drafting. Not just international contract drafting, but a regular contract. What, as a lawyer or a law student, do you think is daunting when it comes to contracts or contract drafting? Anybody? Please put your answers in the comment section.
Agreement taking between two or more parties following
No, I'm
required
asking what
conditions.
is daunting? Daunting as in what is difficult when it comes to contract drafting? What is one thing that you find challenging? Anyone? Guys, if you're not speaking, please don't unmute yourself. Just put everything in the comment section. Okay. So everyone knows what is contract drafting. Nobody finds it challenging? Anyone?
Scope of
An agreement enforceable by law.
No, I'm asking what is challenging about contract drafting. I am
Yes,
saying,
ma'am. Exactly very challenging.
sorry.
It's exactly very challenging to draft a contract, to draft all the points.
Yes. Basically, when you are a law student or you study law, you feel overwhelmed with the fact that you have to draft on your own, right? What law school teach you is the laws related to contracts, but they do not teach you how to draft a contract. Does everyone agree with this?
yeah.
Yeah. So,
Sorry, please repeat it.
sorry.
What do you say?
Please put everything in the chat box because I'm not able to understand what you're saying. It's better if you just communicate with the messages. I'll definitely take up your questions. Okay. So I'm saying that when you are dealing with contract drafting, what I have observed, or when I did my law school, I felt that law school do teach us what are laws. They explain us, they make us understand what are the laws, but they do not teach us how to draft the contracts, right? So that is one thing that I find challenging when I see any contract. And to do it by ourselves on our own, it is quite difficult, right? Does everyone agree with this fact? Does everyone feel the same? Yes. So I have got a new trick, or you can say moreover a systemized way or an organized way to deal with such type of challenges. I have created a questionnaire, a very detailed questionnaire. Let's say, let's say a friend approaches you for legal help, and the friend is from non-legal background and wants help with drafting a contract, an international contract. What are the things that you will consider? What are the things that will come to your mind? As someone who has no experience in contract drafting, won't it be challenging? Won't it be overwhelming? Yes or no? Okay, let's take it like you are starting your freelancing career, or you are just come out of your law school and you get your first client. What is going to be your feeling? How are you going to feel about it? Come on, guys, I want answers. How are you going to feel about it with your first client or your friend when your friend is approaching you for legal help or legal advice? Anyone? Okay. So I as a person who's just passed out from a law school, who has no knowledge or no understanding, no experience in contract drafting, will be extremely clueless as to how to start about. So here I'm going to share something that would, yes, very good, Sneha. Sneha is saying first I would understand his business. Very good. That is good start. So here I'm going to share a document with all of you. Okay. Please listen to me carefully. Listen to me. I'm sure you'll be able to understand. I have tried to make it as easy as possible. Today I'm going to share a questionnaire that will help you to deal with such situations. Okay. This questionnaire is a systemized form in which you can gather information for your contract drafting. Okay. Even if you start, let's say if you find a sample related to a contract, it's always difficult to contemplate what are the possible facts that could be eventually drafted into these clauses, right? Even if you find a sample draft for an agreement, it is still difficult to gather information, isn't it? There is a possibility that you might miss out on some information when you're dealing with contract drafting for the first time, whether it might be domestic or international. Yes or no, guys? So it's extremely important to have a systemized or organized approach when you are dealing with any freelancing work, or first time you're dealing with your client for contract drafting, or whether it is an international contract. Am I clear? So let's begin with the session. Let me know if you can see my screen. Is it visible? Okay. So we have a factual scenario here. Okay. Imagine your friend Arjun approaches you for help as he is starting a new business. Arjun is planning to launch an online store that sells eco-friendly products such as reusable bags, water bottles, and biodegradable packaging. He needs your assistance with drafting contract for one of his key partnerships with manufacturer based in Germany. He wants a contract with a manufacturer in Germany for his business he has started in India. Now, this person Arjun, who is your friend, wants to start an online store. Okay? So when he decides to start an online store, he wants to build a business relationship for manufacturing his products with a manufacturer in Germany. So here Arjun is going to get into a manufacturing licensing agreement. Okay. This manufacturer will produce eco-friendly products and ship them to India. Or it can also be a goods sale of goods. Okay. So in that case, the law that will be applicable will accordingly change. If it is a manufacturing license, the IP law will apply. Or if it is a sale of goods act contract, in that case the customary law, the business behaviors, or the international law related to goods act, sale of goods act will apply. Okay, this manufacturer will produce eco-friendly products and ship them to India, where Arjun will sell them through this online store. Now here what I'm trying to explain is, you will find a client who will approach you with their requirement. Okay, here the requirement is little unclear because it is a factual scenario. But in case if it is your friend, the friend will tell you, in case Arjun will tell you what type of contract he wants. Since Arjun is new to the business and international contracts, he is relying you to ensure everything is legally sound and fair. Okay, so now what do you think is the type of business, or sorry, information you will gather to form an agreement for this type of business? Anyone? IP law will be required. IP law is intellectual property law. In case of manufacturing, you will need the IP. You will need to understand the IP law. Anyone? What kind of business? First, what is the business you will business information you will start with to draft an agreement? Any type of agreement. Yes, very nice, Nancy. You will ask who are the parties to the contract, right? So let's see. Let's move forward and see. This contract will include details about product specification, payment terms, delivery schedules, and intellectual property rights, your IP rights. Your goal as a lawyer is to ask Arjun the right questions you want to. You can draft. So you can draft a professional and effective contract that protects his interest and cover all necessary aspects of partnership. Okay. So this is a questionnaire which I have created. Okay. There are 3 columns. First is the category of questions I'm going to ask. Second is questions under those category. And I'm also adding a column which is of explanation as to why this particular information is important. When you are drafting a contract, you just have to know the category and the questions. In fact, as a first time lawyer or a first time legal practitioner, you can make such type of a checklist and a questionnaire and share it with the other party or your client to fill in the data. And then once you receive the data, you can create or draft a effective and legal contract, legally enforceable contract. Am I clear to all of you? Everyone has understood until here? Okay. So as Nancy has rightly pointed out, parties and their information is extremely important. So first thing you're going to ask is, what is the full name of your business? Have you registered it? Why full name of Arjun's business is important is to correctly identify the parties in the contract. The registration details are essential to verify the legal status of the company. If the company is registered or not. What is the type of company? Is it a partnership? Is it a limited liability company? What kind of legal structure the company has? And that is why it is important to know. Okay. Then second question you're going to ask is, what is the nature of your business? This helps you understand the scope of the business and tailor the contract language to Arjun's specific industry. Here, that is eco-friendly products. So here you have to specify you have to specifically ask your client or your friend whom you're working for, what is the nature of your business? As that information will help you to understand the scope of not only the business but the contract your client is going to get into. Because definitely if the contract is in name of the business, it is going to be related to the business, and this type of or the nature of the business will determine the scope of the contract as well. Okay. So, and under this category, the third question you're going to ask is, where is your business located and you're planning to operate and are you planning to operate internationally? If you're planning to operate internationally, international aspects will come into picture. and it will be important for determining the jurisdiction and governing law of the contract. Okay. And location will be the address of the registered business. Wherever the business is registered, you will find the address as well. Then comes partnership and products. Now, talking about partnership and products, the question you're going to ask is, who is the manufacturer you will be working with? Now, you're asking the details of the other party. And what do they specialize in? Because definitely, if you're getting into a contract, you will get into something that is of your help. So, their speciality is something that will also be part of the scope of the contract you are getting into. This defines the other party in the contract and ensures their specialization uh, aligns with Arjun's business need. Here, that is eco-friendly products. Then, the fifth question you are going to ask under the category of partnership and products is, what type of products will they be manufacturing for you and in what quantities? This is important. Okay, now this is important to draft the product specification clause. You need to know exactly what is being produced in what amounts. So if they are running a business, the other party, okay, your client is getting into a contract with, is running a business, what is the manufacturing they are going to do for you? Okay, so this is to determine the product specification clause. The product specification clause will identify the obligation other party has to fulfill as to the product's quality standards, etc. So that is why this information is extremely important. How will the product be shipped to you and who is responsible for the shipping cost? Now, if you see, the language of these questions is extremely easy. And this is how it is supposed to be. The reason to that is because all these questions are going to be asked to a layman who's your client and has no awareness about the legal terms or terminology. Okay. So, whenever, if you're sending a soft copy or a physical copy of drafted questionnaire, please make sure that you use a language which is understandable by layman. Okay. Now, when you're asking about how will this product be shipped, basically the shipping information, this information will help draft the delivery and shipping clauses, including liability for shipping cost and risk of loss during the transit. Who will bear the cost if there is any loss during the transit? So this particular clause is going to help you draft that information in the contract. Okay. Now, the seventh question is, what is timeline for the product delivery? Definitely, if there is a product delivery happening, you have to mention a timeline to streamline the contract. If you don't mention a timeline to streamline what is the timeline for product delivery, there is a chance that this particular contract will fail and ultimately lead to a dispute. Okay. Am I clear? Until here, does anyone have any questions? Everyone has understood, yes or no? Please respond. Okay. Okay. So the timeline also determines a clear delivery schedule, which is important for setting expectation and avoiding disputes later. Okay. Moving forward, the most important thing is payment terms. Now, these questions are extremely important and should be drafted carefully because they are going to define the most important rights and obligation of the parties. Rights for someone who's going to receive the payment and obligations for someone who's going to make the payment. Okay. How much will you pay for the products and what payment method do you prefer? So here you are going to ask uh, two important criteria for the payment terms. That is the payment details regarding how the price will be paid, how much the price will be paid, what will be the currency method, that is if it is an online transaction, if you want the transaction via bank transfer or PayPal or UPI, whatever it is, you have to mention here. Okay, I mean your client will mention, and eventually you will draft it in the payment clause. Okay, moving forward, second question related to payment term is, will you pay the full amount upfront or would you prefer payment in installments? So there are two types of payment in any contract, whether it is domestic contract or an international contract. These two type are lump sum money and payment in installments. Okay. So lump sum is, you're not going to make payment in installment, you're going to pay at the end or in the start. All the amount. Okay. The full payment will be done either in lump sum, that is either in the starting of the contract or once the contract or the product is delivered or the performance of contract is done. Second is in installments. Installments can vary according to the needs and requirement of the parties. It could be monthly payments, it could be thrice once 3 months, or it could be once in 6 months, or it could be once in a year if the contract is longer. Whatever, however it is according to the understanding the requirements of the parties. Now, this information will help decide whether to include a payment schedule, and if so, how it should be structured. Now, payment schedule is generally annexed to your contract. It is actually technical because the payment schedule decides how much money will be. This is actually used in when the contracts are extremely complicated, like construction contracts. There, the payment is a big problem because if the contractor is not paid, he will not have money to buy uh, the products and will not be able to work. But that is not always the case. So according to the situation, according to the facts of the case, according to the needs of the parties and your client, this payment clause is going to change. Okay, then the last question in this payment terms is, are there any penalties or interest charges in case of late payment? What will happen if one party fails to make the payment on time or follow the timeline that is mentioned above? The penalties for late payment should be clear to avoid confusion and ensure both parties stick to agreed payment timeline. In case if a party's if a party does not make the payment as mentioned or according to timeline that is stipulated in the payment term clause, in that case what will happen? If the party has to make any penalty for that, in that case it will be mentioned in the penalty clause under the payment terms. Okay, now everyone has understood until payment terms? Yes or no? Okay, let's move on to intellectual property. Your intellectual property is generally compromised when you are getting into a contract. So it's extremely important to protect your intellectual property. So you'll ask your client these two questions related to intellectual property. Will the manufacturer use any of your designs or branding? If Arjun provides designs, logos, or branding, this information is necessary to be information is necessary to protect his intellectual property rights. So you're not going to jump on how to protect his intellectual property rights. Rather, you're going to first understand what is the intellectual property right that has been created, either created in this contract or business relationship, or shared during this contract or business relationship. Okay, then you're going to ask the second question related to the intellectual property is, do you want to include a clause stating that the manufacturer cannot use your designs for other clients? Yes, now you're talking about the protection. But first you have to understand what is the intellectual property right, if any, created during the business relationship or shared during the business relationship. This would protect, the second question, this would protect Arjun's exclusive right to his designs and prevent the manufacturer from sharing them with the competitors. Okay. Then comes confidentiality. Extremely important. Will the manufacturer have access to any confidential business information? If yes, what are you going to do? How are you going to protect this confidentiality? What is the clause or the agreement related to confidentiality clause called? Anyone? Anyone wants to answer this? It's called non-disclosure agreement or a confidentiality clause. Have you heard of non-disclosure or confidentiality? Anyone? So this particular clause or an agreement related to that helps to protect your client's information if or to be helps to protect as in from exploitation of that information if any information is shared or created during this business relationship. So first, once you understand what are the IP that are created or shared during this business relationship, you have to work on the confidentiality clause. Not just IP, but anything related to your marketing strategies or anything that is extremely confidential, your client's data, your client's business data, or anything related to that, whatever it is that you or your client wants to protect, has to be mentioned as confidential under this particular confidentiality clause and should be protected. Okay, so if you are first, you are going to ask, will the manufacturer have any access to business confidential business information? Yes. If yes, then what is the confidential information the manufacturer will have the access to? These are the questions you have to ask when you're drafting the confidentiality clause. Okay. Then comes warranties and control, quality control. You're going to ask the question, do you expect any quality guarantees from the manufacturer? Quality warranties ensure that the products meet the agreed standard, which is critical for protecting Arjun's business reputation. If Arjun is going to buy products, let's say this German company has shown Arjun a sample, okay? And Arjun has been following this sample and trusting the company and saying that, yes, I want to go ahead. If any guarantee is made from the manufacturer side that yes, we'll follow the sample standards and will provide you all the products which you have asked for. If yes, definitely it should be mentioned in the warranties and quality control clause. Then comes what happens if the products are defective or do not meet the agreed standards. Now we have put the standards, but what next? What if the manufacturer does not follow? This helps you to draft clauses regarding defective products and remedies available. That could be either replacement or refund. Okay. Then comes the termination and renewal. Under what conditions you would want to terminate the contract? Example, breach of contract or poor quality. See, now if your friend Arjun is getting into a contract, you would want Arjun to be protected in case of the standard, the quality is not followed by the manufacturer. Arjun should have the right to terminate the contract on this ground. So how are you going to do that? You're going to have a term and termination or renewal clause. Okay. Under this, you are going to ask, Arjun, what do you think? Under what conditions you would want to terminate the contract? Arjun will say, if they don't deliver the number of products, if they don't match the quality, all the questions will be answered by Arjun. And according to that, you will draft the term and termination clause. Termination clauses are essential to protect Arjun if things go wrong, such as consistent delivery failures or poor quality products. Okay. Then comes the next question that is related to that is related to termination and renewal. Will the contract be fixed term or do you want to be automatically renewed? Now, what is fixed term? Fixed term is when Arjun says that we are going to get into this relationship, business relationship for 5 years. Okay. Now, what is automatically renewed? Fixed term, everyone has understood. It's very easy. You set a term in your contract and that becomes a fixed term. After that, the contract is automatically terminated. But when it is automatically renewed, it means that for 5 years, after 5 years, it will be automatically renewed for 5 years. In case after 5 years, in case if Arjun or the other party wants to terminate, they can terminate. Now, unless terminated, the contract will keep renewing. Am I clear? Has everyone understood? If it is 5 years and automatic renewal after 5 years, after every 5 years, it will keep renewing until and unless one of the party, either of the party says that I want to terminate this contract. Okay. Unlike that, in fixed term, once the fixed term is over, the contract will be automatically terminated. Okay. This particular information will help decide if the contract should have an end date or if it should automatically renew unless either party gives notice to terminate. Okay. Now let's see what is the dispute resolution clause and governing law. In case of disagreement with the manufacturer, how would you refer to resolve dispute? When you talk about dispute resolution, it is the form of ADR mechanism that is followed generally in this clause. The types of ADR mechanism that are available domestic and internationally are: first is negotiation, mediation, conciliation, and arbitration. Okay, so these are the commonly followed ADR mechanisms. You are going to ask Arjun if you want to go for negotiation first, then go for mediation, and then go for conciliation, or then go for arbitration. If Arjun wants to follow this process, definitely Arjun can. If Arjun does not want to follow this process, Arjun can decide on going for negotiation and then directly go for arbitration. Am I clear? Everyone has understood? So this is exactly what you're going to ask. Arjun can choose, your friend, your client can choose whatever you want, your client wants. It's not like they cannot. They have the right to choose whatever they want. It's just that you have to make them aware about the possibilities your client has. Okay? The question is important for drafting a dispute resolution clause, such as mediation, arbitration, or going to the court. They can definitely go to the court also, but generally, when it is an international contract, they would not prefer to go to courts. They would rather go for ADR mechanisms. Okay. Then, second is to determine the governing law. If the parties are from two different countries, it is extremely important to ask this question: which country's law should govern the contract? Now, because one party is Indian party and the other party is German party in this situation, it is extremely important to choose the governing law, because the governing law you choose are the laws that will determine the rights and obligations of your parties. If your contract is legal, what are the rights available to both the parties? What are the obligations or duties the rights have to perform? Everything will be determined by the governing law. The choice of governing law is critical, especially since this is an international contract. If it is an Indian contract or a domestic contract, the Indian law will apply. Definitely, when both the parties are Indian, it will not be a problem. But in case of international scenario, it is critical and essential to determine. Both parties must agree on which country's legal system will be used to interpret the contract. Okay. Then comes risk management. Here, we have almost come to end of the questionnaire. Risk management is something important. Why? Because generally, people do not owe up to their responsibilities, especially when they get into a contract. And if it is an international contract, it is very difficult to communicate. And that is why Your communication is only through your contracts, and that is why your contract has to be extremely detailed with what are the rights, obligations in every possible way. If there are any potential risk associated or allocated with the contract, who will bear the cost? What are the potential risks involved, and how do you want to handle them? When it comes to delays, defects, currency fluctuation, how all these factors, because these are changing. Delay is something that is not in your hand, right? Defects, sometimes, yes, definitely it's not always the manufacturer is at the fault and does not want to match the sample that the manufacturer has provided. But that sometimes it happens that there are defects. Who will bear the cost? Defects can cause delays. Who will be responsible for the delays? Right? Because if Arjun is getting into contract with the German manufacturer, he has got into multiple contracts here in India to sell his product. Who will answer his further clients? Right? So all this situation should be taken into consideration, and this question is extremely important because it will help you identify risk, help draft clauses for liability, force majeure, and risk mitigation, making sure Arjun's business is protected from unforeseen events. Now, what is force majeure? Force majeure is a type of clause that is included in a contract which says that, which protects one party who is unable to perform the contract because of act of God. So, something that is unforeseen by the party, but enables the party to perform the contract, like any war, calamity, any pandemic, any type of a situation which can cause a party a non performance of contract is called act of God. And to protect a party from such type of situation, you get into a force majeure clause. Okay. Am I clear? Everyone has understood this questionnaire? Yes or no? Does it, I just want to ask all of you, does it feel more easier to go through the drafting process like this rather than taking a sample agreement and just start drafting? Won't it be easier if you're just starting as a lawyer? Won't it be easier to, get a questionnaire done and then send it to your client, and then once your client provides you with the answers, then start drafting? Because samples are available everywhere. The problem here is with actual drafting, right? So having a questionnaire makes everything look more easy. Now, if you actually have the answers to this question, drafting this contract with the help of a sample agreement would not be a problem, right? Does everyone agree with this? Yes or no, guys? Yes. So I feel even when I started, I was maintaining a questionnaire for drafting my contracts. Because when I started drafting, especially international contracts, it was difficult. I would not understand, especially when it comes to choice of governing law and everything. Always understand. You, as a lawyer, do have the understanding of law. But ultimately, the product, that is the contract, is the product of parties' agreements. So you don't have to worry. You have to just know the appropriate information, take the information from the client and put it in the sample agreement that you have. Okay, am I clear? Yes, Anwar, I would like to share the sample, but right now, today the class was related because we have time constraint, and that's why the class was only related to the questionnaire. For you to understand, it's not that difficult. Okay, and as we, I mean, in the international drafting course, which or I don't know how many of you have already enrolled, but definitely that course is going to deal in detail with each sample and checklist for all types of contract to understand the details, minute details of drafting when it comes to drafting contracts. Okay. Here down, I have explained each question. Same, why full name and registration is required, what is the nature of the business, and how the nature of the business is going to define the scope of the agreement. Location and operations is going to provide you with the address. The manufacturer and the specialization is going to identify the other party, and specialization is going to determine the clause related to the product details, product type and quantities, the quantities of product, shipping and responsibility, who is going to be responsible for the shipping cost, and if there is any delay or any damage during the transit, who is going to be responsible, how the delivery timeline is going to work, when which is going to set the expectations of each parties, then the payment detail, how the payment is to be done, what is the mode of payment, whether it is in installment or lump sum, everything is mentioned in detail. Then the late payment, if there is any late payment, what will be the applicable penalties? Intellectual property, what is the intellectual property? What is the information that is created, intellectual information that is created or shared during this business relationship? A confidentiality clause for protecting this shared information. Okay. First, you're going to ask what is the shared information. You're going to define what is the information that is to be confidential. Then comes quality control. If anything that is promised, you're going to set quality standards and expectation and remedies in case of defective products or if the quality is not met. Then termination renewal, both parties will have the rights in cases of you are going to have grounds for termination. Then comes dispute resolution, which is going to be important to decide the methods for resolving dispute, whether ADR or litigation. Governing law, extremely important in international contracts because it determines how the contract is interpreted and enforced. Risk management is going to identify any potential risk because see, your job mostly is in the risk management. You are going to identify potential risk. Okay. And accordingly, you're going to draft clauses that could mitigate, ensuring Arjun is protected from unexpected events like delays and defective products. This basic questionnaire provides a comprehensive guide for the first-time lawyers who to gather all the information from a friend who's starting a business and needs a well-drafted contract. The questionnaire ensures that all aspects of partnership are legally sound and that Arjun's interests are protected. As Arjun, being your client, you have to be extremely careful about his protections, his interest to be protected. Okay, and that should always be your goal while drafting a contract for your client. All right, here we come to the end of the session. Does anyone have any doubts, anything you want to ask related to what we have discussed today? I have not let anyone unmute is because I did not want to disturb the flow of the class because it gets confusing for everyone. If you have any doubts, please, I'll wait. You put it in the chat box. I'll definitely take all your doubts.